Welcome to the Law Awareness Weeks at CDC 2023. This webinar is part of Law Awareness Weeks at CDC 2023. It is a collaboration between Pro Bono SG, the 5 Community Development Councils, National University of Singapore Faculty of Law, Singapore University of Social Sciences School of Law, Singapore Management University School of Law, the Singapore Corporate Counsel Association Pro Bono Chapter, and the Singapore Association of Social Workers, supported by the People's Association. I am Nadia, and I'm your host for this webinar. Today's webinar is dealing with or encountering family violence. First, some housekeeping matters. Today, we will be using Pigeonhole Live for our Q&A session. You can submit your questions at any point during the webinar and also upvote on any questions that interest you. If you have a smartphone or a tablet with you, just launch your internet browser and enter www.pigeonhole.at into the address bar. Next, key in our event passcode, which is Law CDC 2312, as shown on the slide on your screen. Alternatively, you can click on the link shared in the chat function to launch Pigeonhole Live on your device. If you're viewing this webinar on your desktop or laptop, you should receive an invitation to launch Pigeonhole. Please note that today's discussion is not intended to substitute any form of professional legal advice. If you require specific legal advice, please consult a lawyer. With that, I would like to introduce our panelists for today's webinar. We've got June Lim and Kristine Lam. June is the Managing Director of Eden Law Corporation, a low bono private law firm committed to providing competent and affordable legal representation to clients of modest means and underprivileged communities throughout Singapore. She has a keen interest in matrimonial matters involving child abductions, relocations, and foreign wives living in and outside of Singapore. June volunteers with PBSG's Criminal Legal Aid Scheme, the Legal Aid Bureau, and Community Justice Centre. Kristine graduated from the National University of Singapore with a Bachelor of Arts degree, majoring in social work. She joined Care Corner Family Service Centre, Queenstown, in 2012 and is currently an accredited registered social worker with the Social Work Accreditation Board, Singapore. As a social worker, Kristine works with families who are faced with issues relating to financial difficulties, single parenthood, mental well-being issues, and family violence, among others. Kristine's special interest area lies in protection work with individuals and families. Kristine and June, thank you for joining us today. Now, onto the topic at hand. Let's begin with a very basic question, because I'm sure our audience has a rough understanding about what family violence is. But maybe, June, you can give us a bit more understanding from a legal perspective. What does the law define as family violence? And also from the new law that was passed, how has it been expanded?
Okay. So, well, under the Women's Charter, the definition of family violence, at the moment, there are 4 categories. So, number 1, willfully or knowingly placing or attempting to place a family member in fear of hurt, causing hurt, actual hurt, to a family member by a family violence act, which is known or ought to have been known to would result in hurt, wrongfully confining or restraining a family member against his or her will, and then lastly, causing continual harassment with intent to cause or knowing that it is likely to cause anguish to a family member. So this is a definition under the Women's Charter at the moment. Nadia, you're quite right to say that a new bill was actually passed in July, which expanded the definition to include psychological, emotional abuse, coercive control. So that is actually going to come into force, I think, maybe sometime next year.
Thank you. Maybe from a practical angle, Kristine, you can give us a bit more information about how you see this happening in society, the cases you've handled. How have you seen family violence being projected, being exercised against?
Yeah. Okay. So I think people are very familiar with physical violence causing physical hurt, but in terms of family violence, there can be really many types. Where we talk about like psychological abuse, emotional abuse, sexual violence, even spiritual violence, legal abuse, etc., etc. So some common methods may include like name calling, calling people a slut, a prostitute, animal, sex slave, etc. Bad mouthing people, like spreading tales online of like the person's mental well-being, saying that the person has depression and thus act in a certain manner. It can be like using religion to control another person. Sexual violence, it's above and beyond penetration. It can be molestation and everything in between in that sense. Recently, I think we are hearing more and more people talk about gaslighting, which means it's really causing somebody to question their subjective understanding of reality. And the other common word that is buzzing in the family violence field will be coercive control violence, where it is really not the action itself, but the intention. So for example, the perpetrator may possibly send a flower to a victim. And usually people receive flower, the answer is, oh, so sweet. But it might be to remind the victim that I am watching you even though you are in office. Or if the victim has left home, it is essentially telling the victim, you can choose to hide, but I know where you are, and that's why I can send you a flower. So it's really the meaning behind it, instead of the action that might be causing the whole fear and worry.
So it sounds like coercive control. It's the intent behind the action that's really important.
Yeah.
Okay. So I think just so that our audience understand, because we've called it the Women's Charter, it doesn't apply only to women, right?
Oh no, definitely. So all family members, male or female, would fall under the definition of family violence.
And just so we understand, children, for the purposes of this legislation and for coverage, does it cover everyone up to a certain age? Is there a change that's coming in for both of you, any of you to
Okay, I think it's the definition of family. Family is defined by relation of blood or by marriage. So as long as we can prove that the two person is related by blood or by marriage, they can qualify to apply for personal protection order. The only exception is ex-spouses. Even post-divorce, they still can apply for personal protection order. In terms of age, the main difference is children below 21 will require someone else to apply on their behalf. And with the new law change, persons below above 18 will be able to apply on their own. Yeah.
I think you called out a very key point, and maybe June, you can build on that for me, which is it has to be a family member. So what about if it was a boyfriend that was the abuser?
Yeah, so at the moment, under the law, an intimate partner, a boyfriend, a girlfriend is not a family member, and and therefore you're not entitled to apply for personal protection order under the Women's Charter. However, I mean that doesn't mean that's the be all and end all. There is the Protection from Harassment Act, and there is a harassment court. So you would apply for a protection order under POHA instead.
Okay, thank you. I think maybe we'll next move to how to protect myself. I'm sure if anyone's listening in and they want to know how can they protect themselves if they're in a situation of this nature. So, June, what protection does the law give you if you are in a situation? What can you ask for?
Okay. So, I mean, let's drill down a little bit into a personal protection order. It is an order of court issued by the court which prevents the offender from using family violence against the victim. And you also cannot incite or assist someone else to use violence against the victim. So, I mean, that's the comprehensive order that everybody's applying for in the family courts. So who can apply? Anyone above 21, or if you're under 21 and you are married or have been married. How do you apply? You can apply for a PPO either physically at the family justice courts, or a lot of people now apply online. You can apply on this website. It's called iFEMS, and you can just Google that. And you know, can upload your documents. You can put your complaint in online as well. And I think Kristine at the family violence
for the
specialist
protection specialist centers, the three around Singapore, you can actually come down physically, but appointments need to be made. Yeah.
Yeah, so there are a couple of avenues where you can apply for a personal protection order for yourself or for children. What are the other forms of orders that you can apply for when you apply for a PPO? Number one, an expedited order. That is a temporary PPO, which is issued when you apply upon application, and the judge feels that there is an imminent danger of violence being committed. So that is particularly useful, especially if you feel that the perpetrator is going to come after you once once he realizes that you've applied for a PPO. The second one is a domestic exclusion order, or DEO. This is an order of court which excludes the offender from a place where the parties have been residing as members of the same household. So typically, people will try and apply for DEOs for this whole household, but typically the court will order a DEO only for one bedroom or the kitchen or selected areas. Basically, they want to maintain a bit of a balance between the perpetrator being able to live at the place as well as protection for the victim. And the court can also make counseling orders for parties to attend counseling, including their children, because ultimately family violence is it is a very traumatic event. It is something that both sides, the perpetrator and as well as the victim, need help, and they need help to examine, why did this happen? How can we prevent this from happening again? So I would say a counseling order is a particularly important order in the circumstances in this situation. And then, of course, if you're not a family member, then please go and get a protection order under POHA instead.
Just on the PPO, is there any other order that would be usually issued with it, or is it always just the PPO that will be issued if you ask for it? Or and also just on that point, can you ask for multiple different protections and see what the court gives you?
People tend to apply for multiple different protections. Typically, a PPO goes together with an EO, an expedited order, because there would be an imminent danger of violence being committed.
Okay. And just in relation to the DEO, just in case someone's listening and wonders, if they don't own the property, but the property is owned by the perpetrator, would the DEO still be issued to them?
It is possible. So ownership of the property versus whether a DEO can be issued are not directly related, but it will go back to, if the perpetrator have to live outside home, where can the perpetrator possibly go? And if the property belongs to the perpetrator, he or she can always sell it. Yeah, and then the DEO will no longer be enforceable in that sense. Yeah.
And I think one other avenue that we had discussed previously was the letter of undertaking that is just available if anyone wants to, say someone was thinking about it, how that would be something that's offered to them as well.
Yeah, so typically what happens, you apply for the PPO, and then at the first mentions hearing, parties are given the opportunity to resolve things by going off to counseling, and then they'll try and talk it out and see if they can resolve it. One of the ways of resolving it without going to a PPO, which it is quite a severe, we mustn't take the PPO lightly, because the breach of a PPO can result in an imprisonment offense, an imprisonment sentence. So we mustn't think that the PPO is something that is just, any old piece of paper, okay? Because it really does have legal effect. So sometimes people choose not to go so far because they feel that the relationship has not deteriorated so far, and they try and resolve things through a letter of undertaking, which is basically a promise to the court that they will not commit family violence again. And that is just one of the avenues that people choose to go down in order to resolve their disputes.
Thank you.
Maybe to highlight, the letter of undertaking does not have any legal power. It's just a promise in the presence of court. But sometimes, if like the alleged abuser, the respondent, disagree to sign the PPO and they have to go for mention and court trial, it can be very draining in terms of relationship, in terms of emotional well-being and all that, for the victim, for the perpetrator, for the family. So for the sake of the relationship, or like the victim might not feel like she or he is so ready to go through the whole court process, which can take another like 3 months, 6 months, might then decide to opt for a letter of undertaking at that point in time. But this would also mean that if the victim choose to change their mind to want to apply for a PPO, there must be a fresh incident of violence. Yeah.
Okay.
So perhaps we want to talk to the court counselor about the pros and cons of making this decision and what is the real implication for like each of the situation.
I think the natural course from that would be, and you both touched on it, is the PPO usually being applied for when the situation between a husband and wife, say, is so dire that they're likely to go down the divorce route?
I think Kristine and I have different opinions on this. This is where we'll have different. So from my perspective, because I am a family lawyer, by the time somebody comes to me with a family violence issue, they're most likely also thinking of divorce. So I'm a bit maybe biased to say yes, victims of family violence usually end up down the divorce route. But I'll let Kristine share.
We've known each other for 10 years, so quite funny. Okay, so when somebody approach a social worker and they are considering to apply for personal protection order, more often than not, what the victims want is to make it clear to the perpetrator that violence is not condoned and that they want the perpetrator to take responsibility. So the main idea is, I want to break the secrecy. I want to make it clear that family violence had happened. I want people to watch so that perpetrators will think twice if they choose to commit family violence again. So that is usually the main aim of the victim that comes to me. And for that, whether it leads to divorce and all, it is not it's not like it doesn't come in a package in that sense. So people do come apply for PPO, and I have seen many marriages that work out later on after PPO is being issued. Perpetrators who come forward and say like, I didn't know that this was not okay. I thought it was just this and that. So I do hear success story and see success story on my end, and it's not always tied to divorce in that sense. Yeah.
I mean, maybe if I can give a different perspective from a family lawyer's perspective. When they do come to me, we've been talking a lot about victims, really genuine victims, and I'm not definitely discounting that there are definitely genuine victims of family violence. But I also have a lot of people who come to me who have had one-off incidents of violence, right? So not a perpetual family violence, like it's a pattern in their family, but something happened, they had a very heated quarrel, and then somebody pushed or something like that. So it's really a one-off incident. And they feel the need to then file a PPO to punish the other side, or they may have already had other marital issues, and they are using this PPO as a spark to say, okay, I'm going to go ahead with divorce. I mean, what I want to say to people like that is that I'm not saying that it didn't happen, the family violence didn't happen, but I'm just saying that you should consider more holistically whether you must go ahead with a PPO for your divorce, because you can file for divorce on a whole host of other grounds. You don't need a PPO to file for divorce. It doesn't necessarily help you get more money, help you get more time with the kids, deprive the other side of access to the kids because there is the existence of a PPO. I think we have to be very focused and understand that a PPO is focused on protection of victims from a very, how to say, like a pattern of behavior that has been happening, and it is right, it is correct, and as a society we should step in and correct that that pattern of behavior. But if you're using it for divorce purposes, then I would say let's not go there. We can deal with divorce separately in other ways.
Yes, it's not it shouldn't be used as a ground for divorce and apply for the purpose of getting a ground for divorce. It is really for protection. It's not retributive justice in that sense. Yeah, not to punish the other person.
So we've got a question which I think may be linked to something, Kristine, you were going to talk about, which was entrenched dependency. The question is for SWs. How do you engage perpetrators undergoing CGO who do not acknowledge impact of their violent actions?
Yeah, so I think this question likely come from a social worker. Yeah, so there will be times where counseling orders is being assigned, and then the perpetrator just flatly deny, like nothing happened, etc. So I think as a worker, we cannot, it's not our role to figure out what really happened, what didn't happen, but really for them to decide from now on, to the future, what does it look like? So for me, what will be important is to do contracting. Okay, you can say that nothing had happened, all these are not true, but the fact that the judge say so is not my duty to go and discount or to talk anything about what happened. If you want to appeal, you may decide to go ahead. But as far as we are concerned, you are here for counseling order. Let's talk about what do you want for your family and what might be helpful to be done and all that to reach there. Because ultimately, right, there must be something wrong or something that is not working out as well within the marriage, within the relationship that resulted in one party making that decision to apply for PPO. So since we have to meet in the first place, what can we actually talk about, discuss about to make the family situation better? But in terms of the court matters, I would think it is out of our hands as social workers. Yeah.
Thank you. I think I think maybe just for the audience, if you could explain what entrenched dependency is, Kristine.
Yeah, so I think there's a mention of adult entrenched dependency. It is it's like we talk about child abuse, elder abuse, spousal violence, etc. Adult entrenched dependency is a type of violence that happens between usually a parent who is able to care for their child, and their child even at 20 plus 30 plus years old has not been able to live independently. So what happened is instead of the usual launching to adulthood independence at 20 plus 30 plus years old as a normal life trajectory, this group of children continue to demand the parents to provide for them. And the parents, knowing that the child lack life skills, working skills, communication skills, etc., they continue to like accommodate to the demand of their children. So this is not so typical, because usually we will view it as perpetrators are the one that have more resources, more power, and then victims are the one who might not be working, might have dependency. But for adult entrenched dependency, it is the other way around. And the reason why adult parents are willing to allow their children to continue to abuse them despite of everything else is not because they are permissive, it's because they are really worried that their children will not be able to survive in the real world, given that they don't have the skill set. So it's not, as in, I think the usual concern is we will then think that, yeah, your son already 20 plus, 30 plus, you still provide money. It is your own issue, it's your own problem because you choose to be permissive. Then for us, it's really to understand that it is the fact that these children are not able to care for themselves, and the intervention that might be helpful is really supporting the parents to gain safety, and then looking at how we help these adult children in their 20s, 30s to gain real life skills to take care of themselves. Yeah.
And June, from your perspective, have you seen how these sort of situations kind of play out in courts?
Well, we've been talking a lot about PPOs being applied between spouses or between parents and children, but it does, family members, it could be between parent and child. Where we were talking about entrenched dependency, you will sometimes find family violence happening between the child the adult child who everybody feels should know better, but because they're so entrenched, they don't have the life skills to go out, get a job and things like that. And when the parents try and say that, I'm sorry, I don't have any more money or something, that's when some of the family violence incidents might happen. And then that's where I would say a counseling order is quite useful, not really blaming on either side, you see. I think that was an important point that Kristine brought up. It's not blaming on either side. It's the perpetrator and the victim both need help in different areas. And that's why we put in place the PPO for protection of the victim. And then we also put in place the counselling order to help both sides.
So it's a balance.
Yeah.
Actually, such cases hardly make it to court. Reason being, the parents will not file a PPO against their very own child. And then usually how these cases get surfaced is when a police report is made by neighbors or medical social worker picked up, like doctors picked up non-accidental injury and medical social workers was being brought in. So it's usually like bopian kind of situation where the secrecy of the violence is being broken, or the perpetrator, the adult child, starts self-harming, and then the parents step forward to seek help for their child, maybe their self-harming behavior, possible mental health behavior, rather than the issue of family violence. Yeah.
I actually have something. I mean, I think it's quite the new bill that has been passed is quite useful in this area, because in the past, you know, they would, as long as the victim doesn't want to file by themselves, right, there's nothing very much a lawyer or a social worker can do. But now with the new bill, actually with vulnerable adults, someone else can step in, the MSF can step in, the team can step in, protectors can actually put in place things that will protect the victim, other people who, you know, see this happening.
Okay, I'm conscious of time, so I'm going to move to the next next slide. So the next one is, why does family violence occur or recur? So I'm sure there are many factors that cause an individual to cause harm or violence to family members. There may be mental concerns or previous prior history. So Kristine, from your social work, with your social worker hat on, what do you see as one of the key factors that cause a person to want to harm others in their family or cause family violence, essentially?
Okay, maybe from the perspective of a victim and the perspective of a perpetrator. So for the victim, right, nobody enter a relationship, have children, or anything with some other people with the intention to sever ties or to like divorce and all. So when an issue of family violence happen, right, the victim has to choose either or. I have to choose to either protect my right and say that you cannot use violence on me, and then risk losing the relationship, or allow a part of their dignity and worth to be eroded, to forgive and forget, and remind myself of the good times in the relationship, and try to make things work out. So over time, the more the victim gives, the more like the sense of self, their own pride, their own idea of the relationship is being eroded. The more they feel like, I have already sacrificed so much, why should I leave the relationship? Maybe tomorrow he will change. Yeah. So it keeps victim in that cycle. Plus there's something called like the cycle of violence, where usually after an incident of violence, there tend to be a honeymoon phase, or at least a positive, not so negative period, where the victim may feel like it is worthy to perhaps stay in the relationship, and like, look, there is still good times. So because of that, it makes it very difficult for a victim to just decide, okay, I want out. They need to reach a point of enough is enough. And for perpetrators, I think the question is, why did the perpetrators choose to continue to use violence, right? I would say there are real benefit for the perpetrator when they choose to use violence. Firstly, conversations is easier. I shout at you, I get the last say, end of conversation. Then that allow the perpetrators to make all the decisions at the household, have the last say. If anything they're unhappy and all that, they can just use fear, they can just use intimidation, they can just insult the other person to get what they want. So it gives them the whole sense of power, the whole sense of control. Then the question is, what does it take for the perpetrator to realize that if they continue such behavior, they may possibly lose the relationship? And I think until a perpetrator realize that there is cost to their action, it's hard for them to want to give out this benefit of using violence.
And I think one thing that we were discussing before we started the session was that the victim and the perpetrator don't always have to be in the stereotypical male-female roles. They can actually be vice versa. Is that something you see a lot, either of you, June or Kristine?
Okay, I guess we're talking about spousal or intimate partner
Yeah.
violence in this context. Okay, so I would say maybe a good 80-90% of victims who seek help for intimate partner violence are females, but it can be due to different reasons, such as the social script makes it harder for male to come out and say, hi, I am a victim. I am being hit by a female who is smaller and weaker than me by like just physical build. The other thing is when female uses violence, it tends to be psychological and emotional violence. So it's harder for male victims to be able to like gather evidence or to prove the situation. And it's like females, we might talk to one another and say, oh, my husband treat me this way and all that. Then what should I do about it? But men usually don't talk to each other about this. And even if somebody say, oh, my wife keep name calling me, perhaps the other party may respond with a haha, you are whatever, and then laugh about it, joke about it, rather than saying that like, hey, how could she actually do that to you? This is not appropriate. This is emotional abuse. Like we will expect the former than the latter in that sense. Yeah. So we do see, but the percentage is not as high.
I would think that actually male victims would tend to, because of the shame or of being a victim of family violence, they would tend to bottle it up, and then I might see them as divorce clients instead. They won't naturally come as domestic violence victims or want to apply for PPO and things like that. Whereas you definitely see a whole lot more, 80-90% of PPO applicants are probably definitely female.
So for male victims, I usually see them when they're seeking help on behalf of their children who are also victims of family violence. Then in the conversation, we realize that they are also victims, not just their children. Or sometimes is when the wife apply PPO against them, and then when they come in, we realize that they are the real victim, and the wife is actually the one using power and control, the one using coercive control.
Okay.
Yeah, so it's unusual that they come forward, not so common, that they come forward to say that, hi, I'm a victim of family violence. What help can I get? Yeah.
Thank you. So there's one particular question that has got a lot of attention, which is in relation to PPOs. So with the change in definition of family violence, the court's forms haven't changed yet. So can people who experience emotional abuse get a PPO even if the category is not listed?
Well, I mean, the court form will change eventually, and we hope that it will change by next year. But if you feel that you're experiencing emotional abuse, I mean, you would try and file under the continual harassment, the continual harassment ground at the moment.
Thank you.
Yeah, I guess I have cases that all we see is emotional abuse. So it is really how it is being written in the current PPO form. So if you write for example, my son call me names, and then that's it for emotional abuse under harassment, it might be very difficult. But if we can show that it is continual harassment to the point of mental anguish, such as, for example, my son keep forcing me to sign the same handphone plan as him, and he insisted that we must use the same phone types and etc. And then when I disagree, he will raise his voice at me and ask like and say that I am stupid and uneducated. And when I try to avoid, he will this and that. So if you are able to paint the picture, paint the story, then I do see cases under the current law where there isn't physical violence, but they manage to get it via psychological and emotional abuse, through like continuous harassment to the point of mental anguish. Yeah.
Okay. So someone's had a question in relation to one of your first points, Kristine, when we were talking about the slide, which was in relation to why someone continues to stay in a relationship and there's recurring abuse. So the question is, how do you report a breach of a PPO in such a where you continue to stay with them, and what are the consequences? So maybe Jude, you can help us with that. What are the consequences if we breach the PPO?
So I think people need to realize that the breach of a PPO is a criminal offense. There are criminal implications to it. So I just quickly looked that up. So if you are found to have willfully contravened a PPO or an EO, you can be found to be guilty of an offense, liable on conviction to first offense, fine not exceeding 2,000, or to imprisonment for a term not exceeding 6 months, or to both. And in second or subsequent convictions, of course, it goes up, fine not exceeding 5,000, to imprisonment for a term not exceeding 12 months, or to both. So how do you go about reporting a breach of PPO? I mean, it's the same as reporting any crime. You just go to the police, you make a police report. And I mean, I think a lot of victims, sometimes they find that maybe the police process doesn't work as fast as they do. The police does, they do need time to investigate, and especially because the breach of PPO may have happened within the household, so it's not that easy. I think this is a point that we will go on to talk about evidence in applying for PPOs. It's not so easy sometimes to find hard evidence of family violence or even breach of family violence, because a lot of these things are within the context of a family, context of a household. So people will not say or hide, and then it gets a bit difficult for either the police to investigate or even for the judge to come to an understanding at the PPO trial as to what really happened.
So it's really the setting. And also to bring up, when we are applying for PPO, the legal threshold is actually balance of probability. So the victim just need to prove that family violence has likely happened and is likely going to happen if PPO is not granted. But when it comes to filing for a breach, it then goes all the way to beyond reasonable doubt. It's the same kind of standard where we are talking about any other criminal cases, such as like voluntary causing hurt within the penal code. So in that sense, then the extent and amount of evidence will be relatively different for application of PPO and for breach of PPO. Yeah.
So there's a question that's got a few words as well, which is around lack of physical abuse for a PPO, and what is it, word of mouth, and how, so your word against the other person's word, and how does that work to get a PPO in such an instance?
Okay, so the application for a PPO, of course, is an application before the court, and the court has to assess evidence, right? The court was not in your household when this thing happened, so there's no way for anybody else to know what actually happened. So that I will accept is a difficulty of any court application, and particularly I would say for PPOs, because a lot of things happen within the household. It's not like you walk around, with your phone on record all the time, recording what people say to you, the perpetrator says to you, or videoing what has happened within your household. So people don't behave like this in their own house, right? But yes, there must be evidence. And worst case scenario, when you go to the PPO trial, you should still assert it. If it really happened, then say it did happen, and the court is supposed to assess on a balance of probabilities whether it likely happened or it did not. But the types of evidence that the court will consider in PPO trials are, audio recordings, video recordings, text messages,
witnesses,
so your domestic helper. Sometimes, we really hate to do it, but sometimes your children have to come as witnesses.
Try not to.
Try not to,
Yeah,
but
really.
because it does, you might prove your case, but you have to understand that there's collateral damage on your child, definitely collateral damage. Yeah.
I think on that, I think PPOs for the moment are not a question. So let's move on to the next step, and then we can cover off some of these other questions, which I think will come up in our conversation in the next slide, which is seeking help. So I think from a victim survivor who's suffering abuse, what sort of help options are available to them, Kristine?
Okay, I think first and foremost, what is important is when family violence happen, right? Victims tend to take very long to seek help because of the whole idea of like, if I seek help, does it mean that my relationship will end? Does it mean that I'm bringing shame to the family? Does it mean that I'm betraying the relationship? Does it mean that I'm harming the other person and all? So I think it's important for us as a society and for victim to believe that when you seek help, us as social workers will see it as you are really looking at how you want to resolve the situation at home. So come forward, request for services. You can call NAVH National Anti-Violence and Sexual Harassment Helpline 1-800 777 0000. So it is Googleable. Just Google NAVH. So you can call them. They can link you to the relevant agency. If not, you can consider the family service center that is nearest to your house, or to approach any of the protection specialist centers. Yeah.
What about, again, because it's not just the getting help to get away from the person or protect yourself. What about the mental anguish? Is there anyone who can help a victim with the mental impact that this has caused?
In what sense?
So this something like, so going through an incident of this nature would have a mental toll on you. So would it be the family service center that you could reach out to?
Okay, so when a person seek help for family violence matters, right? First and foremost, what we will really look at is immediate safety. And that would mean that right now whether there's any like how's the person's mental state? Is it safe to go back home? If it's safe, what are some of the plans we will need to put in place while the person continue to live at home? If it's not safe, then the question is, where else can the person stay for the time being? It might be shelter, it might be relatives' house, etc. So those practical things can be planned out. And after that, it will be really looking at what else and like what to do. I believe that because the issue of family violence is about power and control, victim already feel very disempowered within the household, within the relationship. It's not helpful if a social worker come in to impose and expect the victim to have to do certain things. So unless it's a life and death situation, unless there's vulnerable members at risk of harm, if not, a social worker's position is very much working out with victims based on your goal, based on your desire, be it to stay at home, to have a mental break, to share with the perpetrator that certain behaviors are not acceptable, or like there could possibly be certain legal consequences, etc., then we will work out a plan accordingly. And there will be an immediate plan there and then, short term, the next few days, the next 1 week, and then later on to work out a longer term plan to say, like, for the household, for example, how to break the secrecy that victim has come out to seek help for the issue of violence safely to the perpetrator. Okay, because actually risk increase in two situations. One is when the secrecy is broken, then the other time is when the victim attempts to leave the relationship. So if we want to call the perpetrator and say like, hi, the victim has come forward to seek help, we need to make sure that it's done safely. It will not be a situation where the victim goes home, the violence worsen, or the victims go home, then there's further like confinement or isolation. So it has to be strategized.
Okay.
Yeah.
Thank you. I think let's just move to the next side, which is helping survivors of abuse with sensitivity. And just on that, June, from your experience, have you ever seen kind of seen when a client comes to you that maybe they may be the subject of family violence, but they're not accepting it, or they're not willing to make it known? Are there signs that people can maybe look out for?
I like to ask, clients that come to me, I do like to ask them about the history of the relationship, what has brought them to my office today, right? And And oftentimes the family violence victims that I see, they span they're both sides of the spectrum, very extreme ends. So I either see the one-off kind, and then they're like, oh, very heated and want to file for divorce. Or I see the ones that have been abused, physically abused or emotionally abused for 20, 30 years. Right. I hardly, there are other kinds of divorce cases that I do that, of course, fall within that spectrum, right? But in terms of family violence, it's always this side or that side, right? And the ones that are on the have been abused for a long time, they may not actually recognize it as abuse. They may think that this is just cultural, or they may think that this is just him, like it's
The
just like
person's
this
personality flaw.
yeah, and that they have lived through this, and maybe they have come for a divorce for some other reason that is not actually abuse. But and this is why I always advise all my divorce clients to go for counseling or to go for divorce support services, because they cannot themselves identify whether they have been victims of abuse, right? I may be able to see trends, but neither am I trained to deal with like what Christy says, like, having to be sensitive as to how you break the secrecy and all these things, right? Neither am I trained to do this, right? I can only identify, I see that these are possible symptoms, and I think this is where you need to go.
Yeah. Okay. And Kristine, from your point of view, because say I'm a friend and I'm seeing signs, but I don't know what it is. How would I be able to identify that maybe my friend needs some support?
Okay. I think when it comes to family violence, right, shame is very real. And it's not just the perpetrator trying to hide the issue of family violence, victims are also trying to hide. So it's important that when we approach somebody who might be victim, it's handled with care. So whether it can be done in a private setting, ask for permission before you ask. Say, like, for example, I noticed that you look very tired recently. I noticed that your makeup is a lot thicker than usual. I'm just wondering, is everything all right? Like, what is actually happening at home? So I think scaffolding, creating that space, before we talk about it, is important. And sometimes victims do offer and say that, oh, this has happened to me, or like I'm a victim of family violence. It's important for families and friends to not overreact. A common thing I hear from victims is like, oh, I sought help earlier on, then I didn't seek help for the last 3 years until situation really worsened. Because the last time I sought help, my friend went like, oh, are you sure? He's not like that one leh. Then it becomes like, did I then shame him? Or like, will people trust me? So it becomes very difficult to share. So for friends and family, I think it's important for us to stay cool, stay calm, all the exclamations stay within, focus on supporting the victim and moving the victim from like coping there and then, thinking about possible options and nudging them to consider seeking help. You can accompany victims to one of the agencies I mentioned earlier to seek for services. Those will be helpful. But again, family violence is about power and control. Victims already feel very forced. Don't force them to do something, but work with them. They do know that it is hurtful for them. They do already know that their children are watching. There can be impact on the children. So also don't emo blackmail them like and say like, think for your kids, you must seek help now. That might not be so helpful. But go on the, I guess this does bring harm to yourself, your child, and I guess you're also thinking about what you want to do next. That's why you're even having this conversation with me. So let's explore what might be helpful for you right now. Would you want to speak with a social worker that can share with you what are some real options out there before you make a final decision? If you are willing, let's go and find someone. So a framing like that might be more helpful for a victim who finally muster up enough courage to share with someone. Yeah.
I mean, my comment that I would add on to what Kristine just said is that a lot of victims sometimes when they come to us, they might want us to be their saviors. But actually for Kristine and I, we play different roles, of course, but we've tried very hard to be facilitative, to provide that scaffolding for victims, and also to understand that the perpetrator, I mean, he or she is not a victim, but he or she definitely has a problem that needs to still also have to be solved in other psychological ways. So we try not to insert ourselves into that narrative that is already happening between the both of them, but we're there to give them options to reframe, to ask questions, to tell them what is out there in the community. We try very hard not to get personal or feel that we need to save the victim. And I mean, I think that's important for family and friends to understand also. Your role there is to listen, not to save.
Yeah, I like what you say. It's like not to insert ourselves into the situation and to comment on like who is right, who is wrong, but really things had happened. It shouldn't be like this. It had happened. Then the question is, moving forward, what might be best? And the last thing we want is like, for example, somebody rush a victim through PPO application, moving out, divorce process, and midway through, I have victims who dropped everything, went back to the perpetrator, and from then on, it is isolation.
worse and
They
worse.
stop sharing anything with everyone, and then we don't know what is happening. Violence could have gotten worse. The perpetrator could use this to further guilt trip the victim and say, you see, you bring me shame, you left me for a moment, so all the more you must make it up to me right now. So I think like working with victims when according to their pace, their readiness is very important.
So based on what both of you have said, I think, and correct me if I'm wrong, it sounds like as the friend, you can't be running on your emotion and anger. You have to be calm and trying to actually figure out what the victim wants to do and help them find a solution for themselves.
Yeah, because if they overreact and then the victim feels pushed and not ready, then he or she will withdraw. And then actually the cycle of violence gets worse and worse. And I mean those are the ones that come to me 20 years later. They may not resurface to people, to the helping profession until 10 or 20 years later. So your overreaction may have caused this. So just be very careful about how you handle it.
Thank you. So we've looked at this from the victim's eye. What about from the perpetrator's point of view? How can we, if we know that someone may be abusing or being violent towards their family members, how can we, well, not support the perpetrator, but how do we give them the tools to deal with it and manage it and, I guess, go forward without continuing down that cycle? Maybe June first and then
Actually, Kristine is
okay.
next.
Okay.
So maybe from a social perspective, the question is like, if you know a person is being abusive, the question is, why would a person want to change? It's not like you tell a person this is wrong, then the person will change. So I think finding that motivation to change is important. So for the perpetrator, usually we talk about what is the cause of violence to them, or what is the benefit of non-violence, such as having someone who agree with you, not out of fear, but out of respect, out of love. Like, is that something worthy for the perpetrator to work towards? So I guess you can tell the perpetrator, hey, whatever you do is not okay and all, to create some social tension. Just be mindful, it will not come across as later on the perpetrator will take it out on the victim and say it's because of you, then I am shamed in public today, or like somebody told me off today. So just be mindful about that. But I do think that where possible, we can create some level of social sanction, even if it's not directly tell the perpetrator that their behavior is not okay. At least interrupt for the victim to know that somebody is seeing, somebody knows what is happening, and for the perpetrator to be reminded that there can be real negative consequences. But that willingness to change, the willingness to try something else, to work differently, it really depends on whether there's a real mandate, be it through the law and all, to work with them. If not, then it is really appealing to the person's conscious and like moral values in that sense. Yeah.
Okay. And from a legal perspective, can the individual who's identified that this person may be being violent towards others, can they do anything via the law? Can they ask for any orders? Is there anything they can do?
Definitely, if you are the victim, you think that that this person is perpetrating family violence, then apply for the PPO. Because I think that applying for the PPO is the first step, going before the court and saying that there really is a problem, not feeling like this is going to be the end of the relationship. Because I mean, in many situations, that may not be the end of the relationship. It's just the start of a better relationship, of a more adjusted relationship.
Okay. As in PPO is a possible way to break secrecy. And just now we talk about breaking secrecy can be relatively unsafe. So with PPO application and hopefully with a expedited order, hopefully that can increase safety in breaking of secrecy. And then it becomes a real problem that we can talk about, because by the fact that the court accepted the application means that it has satisfied the legal and by extension society idea of what violence is. So it's harder for the perpetrator to say that I am not a violent person, which we will agree, but we can say that those experiences, those actions does constitute family violence legally. And then we can have a conversation from there.
And so, sorry, that was from the perspective of the victim, but if that was a third party, so say I was the witness to altercation, can I go and file something against the perpetrator?
They can make a police report.
Okay.
Yeah, and then it will then become a criminal kind of proceeding rather than a civil or like family justice court kind of proceeding.
Okay.
Yeah.
So I think with that, the points we wanted to discuss, we've covered, but we do have quite a few questions that have come in.
This is for you, the top.
So just so that everyone knows what question that is, there's 7 votes for it. After a wife has been lethally attacked, example with a knife, are there any protections for her in co-parenting with the child's father after divorce? Scary to negotiate after attempted murder.
Okay, so I agree that it is going to be virtually impossible to co-parent with someone who, I mean, and this relates to what we were talking about earlier about perpetrators who are recalcitrant, who don't recognize that what they are doing is wrong. So, but if we still have to engage with them because we have children, then what can we do about it? I think in situations like that, especially through the divorce, this would be grounds to ask for supervised access of the children, or supervised or just a supervised handover even, so to minimize the amount of contact between the 2 ex-spouses. So you might want to put another third party in, whether it's a relative or a domestic helper, someone to put in between, and that will still facilitate the relationship between the parent and the child, but it increases the safety of the victim when the perpetrator doesn't acknowledge that the abuse has happened.
But this sounds like it was quite a significant amount.
And I mean, when it is like that, then you do have to keep the relationship very short and sweet, everything in writing. And it's definitely that's with the power imbalance that is not going away, it's impossible to negotiate.
Maybe I wanted to highlight another thing here is sometimes we talk about if a person is abusive, if the husband is abusive towards the wife, does it mean that the husband will no longer get custody or access right to the child? The answer
is no.
No. Yeah. So the answer is no. And then if the child is not a victim at all, there are cases where I see where violence happened, the divorce happened, the child goes to the perpetrator instead of the victim because the victim does not have stable housing, for example. And stability, predictability, near school, etc., ability to care, supervise the child and all that are key considerations, some considerations for custody matters, if I'm not wrong. So because of that, it is not so black and white. when it comes to parenting, at the FAMS at FSC, the Divorce Support Specialist Agency, the divorce module covers, right? There's co-parenting, parallel parenting, and other types. So it's really what is a reasonable, agreeable stance. Just now before the start, we were talking about what do people put inside the custody order and all. Sometimes I've seen clients to really minimize possibility of need to negotiate or to discuss anything after divorce. What they do is they literally write down school holiday, week 1 go with who, week 2 go with who, week 3 go with who, public holiday, who goes when goes with who, Saturday, Sunday, which day father will get the child, which day mother will get the child, what are the special occasion such as Mother Day, Father Days, father's birthday, mother's birthday, to really state some of this as clearly as possible, to minimize situation where they couldn't agree, because to make the custody paper as clear as possible lah. Because it's very real. There's something called post-separation intimate partner violence. You can search it out, and the symptoms are actually very, very similar to intimate partner violence within marriages, just that there's a lot more use of children or the legal systems or system in general for post-separation intimate partner violence lah. My purpose of sharing this is not to sadden the situation, like violence never end, but it is really true and it's reality. The question is then, what can we do to really minimize all the grace, the need to negotiate, knowing that with power differential, it is almost impossible to have a fair negotiation or even discussion. Yeah.
I think, Kristine, during one of our prep sessions, you were talking about a case where the child was moving between houses, and the day before the child was going to the father, the mother was making sure that the child was so exhausted that she couldn't really...
Yes. Yeah, so I was sharing with the panelists that I had a case where the child is with the mom Monday to Friday, then with father Saturday to Sunday. So what will happen is mom will keep the child up on Friday nights to Saturday morning until like 3 a.m., 4 a.m. And when the father gets the child is very tired. And the father has to then decide, do I let my child sleep and then I spend lesser time with my child, or do I still force my child to be able to go out? If I'm not wrong, the father only gets a few hours, not even like Saturday, Sunday. And because of that, then the father just find it very difficult lah. The wife is literally making use of the child against the ex-husband in that sense. And actually this is one typical example for coercive control violence, that you will use something that hurts the victim against the victim regardless of the cost to other people, and these other people is usually either children or like parents of the ex-spouses. Yeah.
Wow.
I think what I would want to add is, I mean, today's webinar is all about protection, family violence and all that. But many of the fields in matrimonial practice for family lawyers, they all kind of intersect, So you'll have your family violence, and that has it kind of comes very parallel to divorce. It also may come very parallel with custody of children and things like that. And there's, I mean, what the point that I was trying to make earlier in the webinar is that a lot of people will try and overlap it a lot. I'm not saying that there is no overlap. Of course, family violence it can be a ground of unreasonable behavior in divorce, and that is something that you can use, a fact that you can use as unreasonable behavior in divorce. That's where the overlap is. But for some people, they make it overlap too much. And I mean, the question that had the most upvotes, that's where the family violence and co-parenting, custody and care and control and access to the child, that's where it overlaps.
Thank you. So the next question that's come in is, how may we protect disabled or non-ambulatory persons from emotional abuse by caregivers on whom they are dependent for activities of daily living?
I guess this question is for me.
Yeah.
Okay, so to be clear, usually, like some people tend to say, right, caregiver stress is a reason why there is disability abuse or elder abuse. But research has made it clear that when a caregiver is stressed, they tend to self-harm, inflict harm on self. They tend to not take care of their own mental well-being rather than harming the care recipient. What changed in the mind of a caregiver to a perpetrator is when the caregiver starts to think that, like, my life is difficult because of you, and that gives a license, that gives a justification to do certain things on to the care receiver. So if there is already that switch that I can justify certain things I do to you, I can blame you for what I'm experiencing, then I would say that that relationship has changed from a caregiver-care receiver to a victim-perpetrator relationship. So I think that clarities need to be made. And usually, if it is really about like caregiver stress and all, what we would do is to bring in additional support to relieve some caregiver duties, and that would actually help the caregiver cope better, and all the other behaviors of frustration, exhaustion, inability to change diaper in time, etc., should reduce. Okay, if even with support, violence continue, then the question is that individual a fit carer? Okay, I have clients who made that decision to hire a domestic helper to watch themselves, to stop themselves from abusing their care recipient. Because firstly, when you have additional help, you can outsource, you don't feel like it's all on you. Secondly, with an external party watching them, violence tend to actually reduce. So for that particular perpetrator, carer, he was very clear that he wants to be watched, and he knows that hiring a domestic helper helps him to be watched. So on the same notion, could we bring in other family members, neighbors, friends, bringing that person to a senior activity center, to daycare centers, for cares, to really reduce such caregiving dependency, and also to increase visibility.
Okay. Yeah. So if I can pivot from that, say the victim or the person receiving the care is actually the wife, and the husband is the caregiver in that situation. How say in that situation the wife needs to get a personal protection order or a DEO. How would that work for them from your perspective, June?
I mean, this is where the new bill actually comes in, to say that protectors can apply for PPOs on behalf of people who may be unable to. Right. So this is where the amendments came in to try and alleviate some of these problems that have arisen, cases that have arisen through the feedback actually of social workers, lawyers, and through the courts as well.
Okay. Currently, there is such provision. One is for children and one is for vulnerable adults. But the definition is tough. For child, it's clear 18 and below. If no one else is applying, actually some appointed social workers are able to apply PPO on behalf of the child. The question is, how can we then enforce it?
Yeah.
For vulnerable adults, there's also such provision where there are appointed welfare officer who can apply on behalf. But it is difficult to be labeled as a vulnerable adult. So with the amendments of the bill, it will then be a catch-all, because we do know that there are victims whom, because of the impact of violence, because of their mental well-being at that point in time, etc., even though they are like
quite functional.
Yes, yeah, but they might not be able to make the safest decision for themselves at that point in time. So the change in law will then allow a more catch-all group in that sense. Yeah.
I think that goes to the next question that's on the list, which is, how do you ensure the safety for the children with special needs? I'm guessing the rest of it's in relation to the divorce proceedings we were talking about, and where you've got shared custody. So how do you ensure that there's no disruption to children who have special needs, and I guess as a result require stability?
I mean, this is again where the family violence provisions and the custody, care, control, and access provisions under the law, that's where they intersect. So when we're talking, I assume when we're talking about safety, we're talking about like physical safety. So that's where the PPO and all these things would protect. But in terms of routines that are more stable for special needs children, that's where the custody, care, control, and access, you've got to draft it well. You have to have an understanding also of what are the child's specific needs, and then how do we ensure that, and we have to present this to the court to say that this is in the child's best interest. And then that's if we cannot get the other parent to agree to such access terms, then we will have to present evidence to the court that this is in the child's best interest.
Is the custody care
and control,
custody care control, is that submitted as part of the divorce proceedings or subsequent to it?
So as part of the divorce proceedings, so in Singapore, basically divorce is in two parts. The first part is the reasons for the divorce. And then the second part, we deal with what we call ancillary matters. So custody, care and control, and access to children, spousal maintenance, child maintenance, division of assets.
Okay.
Yeah.
And from your perspective, Kristine, have you seen any, from practical angle, anyone going through this and how it's impacted them and their children?
My answer would be the same for disability abuse, child abuse, elder abuse, vulnerable adult abuse, the more vulnerable population. As social workers, we look at two key things. One is how do we reduce dependency on the perpetrator? The other thing is how do we increase visibility? So more visibility, more sanction, less chance for violence to happen, then less dependency, less interaction, again, less chance for violence to happen.
Okay.
But having said that, if the perpetrator is very intentional to make it happen, then whether there needs to be more things to be done to even prevent the perpetrator having a chance to be with the child on their own. So when it comes to the vulnerable population, right, what we are more concerned about is really sexual violence. They are 14 times more likely to experience sexual violence, and it is not a matter of male perpetrator, female victims. We see a lot of same-sex kind of violence, or just like the whole idea of perpetrator feeling powerful to be able to do something to someone and see their reaction and their helplessness. So gender no longer matters when it comes to persons with vulnerabilities. They are just a lot more susceptible to violence such as sexual violence. Even for physical violence, they are 3 times, if I'm not wrong, it's 3 times more likely to experience physical violence than the general population. So for us, it's really how do we up that visibility of those possibilities. Yeah.
So in a situation of that nature, how would what can the other partner or parent from that divorce do to prevent this child from having to go through that?
You would have to show that there has been a history of such violence, whether it is emotional, psychological, that sort of thing. I mean, like what Kristine was saying about tiring the child out. You would have to show patterns, and I will appreciate that actually a lot of clients are not very good at showing patterns, and that's why our job as family lawyers is to give them that framework to show patterns. So I mean, one of the things that I share with my clients is an Excel spreadsheet, which I draw up, and I'll say, okay, you put day, date, what happened, write me a diary, what happened, did you request for access, this is what, was access denied, why was access denied? And then having to populate this for 3 or 6 months, then we have data on which we can then go back to court to say that this is this is the evidence of the abuse, and that's why we need to change the access orders. So I mean, I appreciate that a lot of these, whether it's a PPO or in divorce applications, evidence is not something that clients are very good at accumulating. So we try as family lawyers to give you the framework and empower you to collect that evidence.
So there are a few questions that have come as a result of this the family and children that we've been discussing on that subject. Let's go with the one on divorce. So there's one that says, do you think the current divorce procedure sufficiently addresses the needs of women and children suffering family violence?
I think it, like I was actually saying earlier, divorce is one basket. Okay, family violence is another basket. There's still there's some overlap, but not a lot. Okay, so divorce, whether divorce procedures sufficiently address the needs of women and children suffering from family violence, yes, go and apply for divorce under unreasonable behavior, prove that it has happened, and then you will be granted your divorce on the ground of unreasonable behavior. So yes, it does. It always has been an avenue that's available to you. But whether I would say I actually really quite like the new bill, and I am looking forward to seeing it come into force next year, because it recognizes that abuse is not so tangible. It recognizes emotional abuse, psychological abuse, things that, but then balanced against the need for evidence, that becomes a bit maybe more difficult. But we'll see how that plays out next year.
Is emotional abuse defined under the Act or the new existing law, or?
Existing law is very much absorbed within continuous harassment to the point of mental anguish. In the new bill, the coercive control violence is then how we prove to say that it's not the behavior but the intention behind the behavior, or like the patterns that have led to certain impact. Yeah, so it's really how it is being written and the correlation is being drawn.
Okay.
I think the point is to show the control, right?
Yes,
yes, and family violence is all about showing the power imbalance and control.
Mm.
So it is actually not useful for the law to define emotional abuse in any given way, because I assure you perpetrators come up with all kinds of inventive ways to emotionally abuse the other side. So I mean, I've come across things like they will withhold they may force certain sexual acts, or they may withhold certain sexual acts, or they may punish children. Yeah, or I've even had a client who had to who was forced to cane her children when she herself did not want to cane her children. So you would think, like, why would a normal thinking adult, right, like be forced into the situation in a heated moment? But it became a pattern of behavior which was damaging to her children ultimately. So I don't think it's useful actually to define emotional abuse, because the people will come up with the most out there ways of doing it.
As in, not helpful to put examples within the statute. It's like child abuse, like CYPA, Children and Young Person Act. There isn't examples. Yeah, and I thought that is great, because there's just so many different ways it can be done. Then we will go back to what does it actually cover, and how can we actually say that this constitute physical violence and this constitute excessive discipline, and thus it is psychological abuse. Yeah, and then for the lawyers and whatever involved to really show how law can be applied in different contexts. Yeah.
So I think we've got time for one more question, and there's one that's got 3 votes, and it's for June, I think. What can you do when the judge says only physical violence qualifies for DEO and not other violence under the Women's Charter?
I don't think it's accurate to say that only physical violence qualifies for DEO. And I think sometimes when clients go to family court, they tend to get a bit overwhelmed in the proceedings that may or may not be exactly what the judge is telling you. So no, not physical violence goes towards the PPO. But whether a DEO is necessary or not depends on where the physical violence has occurred, where the violence has occurred, and whether it's likely to occur, right?
Or does it take a DEO to stop or like reduce the chances of violence happening? A DEO can help reduce violence from happening, but is it a like necessary must-have in order to stop something from happening? Because DEO does have a lot of costs to the perpetrator. Because like I have families who have to spend like 800 more a month, and that actually reduces the total amount of money the household have in that sense, because he there's a DEO for 6 months and he has to stay out. So I think might need to balance some of those when we talk about it. But this sorry that I cut in.
Yeah.
I'm just thinking like this doesn't sound accurate. So I wonder what might have the judge meant otherwise. Yeah. Or like what was the context that resulted in the judge making such a comment?
I think when we were talking, and there's one thing that we may not have covered, which is the length of a DEO PPO. There is a fixed time limit for them, right? It's not in perpetuity.
Again, the purpose of the PPO is for protection. So you will have some orders that are perpetual. You will also have some orders that are 6 months, 12 months.
Okay.
Yeah.
So in general, they are lifetime, but I do see like DEO for 3 months, or even PPO for 6 months, or PPO to the point where divorce ends. So the court does have the right to design it differently for different families. Yeah.
Okay. There's an interesting question that's got one more, and I'll cover that before we wrap up. What if a husband's verbal emotional abuse is triggered by the wife's mental abuse, gaslighting? So where would the
PPO?
That's what
Okay.
happened.
Yeah. What we thought, okay, so there's actually 4 types of violence. Just give me like a few minutes. So there's the coercive control violence, where we talk about like power and control, intentionality of one person to hurt the other person. There's a clear differentiation in power. Then other types might include couple conflict, where both have almost equal power. Then it's about using violence as a problem-solving method. One is separation instigated violence, where because one person is trying to leave the other person out of fear or like desire to hold back the person, violence happen. Usually it doesn't happen more than 2 times, and the perpetrator tend to be very remorseful, and it tends not to happen again after that stressful incident. The last one is violent resistance, where an individual uses violence as a self-defense method. It's like fight, flight, freeze, the victim fight, and then it becomes an act of violence. If the husband intentionally think that you do this to me, I'm very frustrated with you, and thus I can use violence on you, then I would say it might be a couple conflict, like tit for tat. You do this to me, this gives me the permission to do that to you. If it is a matter of like really violent resistance, that the wife keeps saying false things to the husband and keep causing the husband to question their own reality, to the point where they are feeling mental anguish, where they are doubting their own mental health. We are seeing impacts such as suicidal ideation, inability to trust personal ability to make decision, issues with sleeping, etc. Then we could possibly say that it might be a violent resistance. But again, when it comes to somebody using violence against the other person as violent resistance, it is once off, acute, and very much just to protect self. It will not be a continuous attack on another person. So I would think this particular question is the context really matters. We also don't want people to misuse to say that like, oh, because she did this and that, then it is reasonable. This is a hurt response from me, and then I justify my act of violence. So I think like we need to play a bit safer when it comes to a topic like that. More details will be needed. Yeah.
Okay. June, do you have anything you'd like to add to that?
I mean, from a legal perspective, usually the couple conflict is the divorce. Are those that come to me for divorce? Yeah. Or I mean, yeah lah. So that's all I have to add.
I think with that I'd like to actually say we're out of time and we need to do our closing out bits and pieces. So I'd like to first ask our speakers today, our panelists today, what would you like the audience to take away from today's session? So June first and then Kristine.
I'd like the audience to take away that family violence is not only the victim's problem or the perpetrator's problem. I think you need to see it as a relationship problem. And if you want to save the relationship, then both sides need help. And we shouldn't, be so quick to cast aspersions on either side, one being too permissive or one being too aggressive. But it's just, we have to seek holistic solutions to the problem.
I think on my end, it's really like when we talk about the issue of family violence, we shouldn't just look at family and say, you should give and take, you should let go, you should forgive and forget, you should give the person another chance, you should consider the face and reputation of the family, etc. And you should not just look at violence to say that how could he or she do this? This is not okay. This is against your right. Your safety is at stake. You should consider this and that, like etc. etc. So it's really balancing the fact that violence happen within a family context, and we will need to hold these two things in tension. The only exception is when there's threats to life or when there's vulnerable members present, then we might need to act a bit faster or a bit more like in a manner that we might need to take over certain things in order to protect human life. But other than that, really pacing with the victims, pacing with the perpetrator, creating space for not just justice, but possible healing within the household.
Thank you. So we have to bring our Q&A session to a close. At the end of this webinar, a survey form will pop up on your screen for your completion. We appreciate your comments as it would be used to improve future webinars. In the coming weeks, we will have the last two webinars on advanced legal planning for your later years, but not sure what to do, concerned but unaware about what happens after the demise of a loved one. It's never too early to plan ahead for the future. The most precious gift you can leave your family is peace of mind. We will have a session in Mandarin happening on Monday, 20th November at 7 p.m. and the English session the following week on Monday, 27th November, 2023. These and many more webinars are available as part of Law Awareness Weeks at CDC 2023 and can be accessed via the QR code or by visiting the website go.gov.sg/lawcdc 2023 to register for this webinar or any of the other webinars available. If you have any legal inquiries and are keen to register for a legal clinic session, you may write to help@probono.sg. We would like to express our gratitude to Kristine and June for sharing your knowledge and experience with us this evening. With that, we would like to thank all of you for joining us today and have a good week ahead.